we are. It begins over 2 months in. We finally get to take the City of London to trial, to task over what they have done to the city through their lobbying activities.
Nearly 1 full month since the trial began on December 19, 2011, Judge Lindblom ruled on the controversial civil case of the City of London Corporation versus Tammy Samede, the representative for the Occupy London Stock Exchange movement. George Barda and Danial Ashman represented themselves as litigants in person against the corporation.
We do not accept the cuts as either necessary or inevitable.
Justice Lindblom ruled in favour of the City of London Corporation on all counts. John Cooper QC intends to appeal and was granted 7 working days to submit the application.
The area of public protest law in this country is fast developing, and the Occupy movement are actually pushing the issue as far as legal development on public protest is concerned, which is to the benefit of everyone. People may not agree with everything that the client stands for, but at least we hope they will agree with the judge that they are people of integrity, responsibility and drive.
There has been speculation that the City of London Corporation took so long to take action against the Occupy movement because there was significant confusion as to who owned what piece of land, and therefore what powers could be exercised regarding the health and safety issues and access issues the protest camp allegedly raised. In the map submitted in court by the claimants, we learn that the church owns a fraction of the land currently occupied by the tents, identified as Area 2 in the legal documents.
But whose orders are you following, sir?
My own. I'm the security officer for St Paul's Cathedral.
You can't be following your own. You have a boss.
No, my boss is me. I am the boss.
This is the Canons, and also Mark McVeigh, the marketing director. They said that they would see how it went today with the crowds for the choral services, and then we would talk about it and take it from there. No, you said that no fences would go down today.
No, I didn't say that
Yes,
at all.
you did. You said that then we would see how it goes.
The City of London Corporation are the freeholders of the rest of the land shaded in green and orange that surrounds St Paul's Cathedral. This area is divided into 2 sections. Area 1, which is occupied entirely by the tents, and Area 3, which is the large remainder.
We're so sorry. We really do apologise. We didn't know it was so important to you to keep watching the TV.
An injunction and possession order were sought for both areas. This new given power over all the surrounding area of St Paul's has an indefinite time period on it, which is unusual because injunctions are known to expire at some point.
I'm entirely unsurprised, but I am hugely disappointed that the judge seems to have completely disregarded the arguments that were put about many of the issues specifically to do with nuisance and planning. One of the things he found for example, was that we're obstructing people's right to worship and access to the cathedral, and I think we have proved over and over again that that's an utter nonsense.
Justice Lindblom ruled that the City of London Corporation's rights to have full control over this pedestrian highway, one of the widest passageways in London, outweigh the human rights of the protesters under Article 10 and 11 to assemble and express opinion.
It's not surprising, it's predictable, a little disappointing. We put, I think, a very interesting and forceful argument before the court that the court effectively decided that it wasn't going to rule on. The court decided in advance that it couldn't actually engage with the questions of real political substance that lie behind this movement and that constitute its prime justification. And that was a shame. They allowed us to bring witnesses, they allowed us to make the case and then effectively ignored it. We do have a right to protest in this country that is far more protected than many places, and the very fact that we are standing outside a courtroom rather than a sort of destroyed camp when the police have just kind of come in that is significant, but the right of protest at the moment is certainly not defended in terms of the importance of that protest. Like, the argument that we made was simply that, of course, the right to protest, irrespective of what you're protesting, should be protected. We were suggesting that if you can demonstrate to the court that it is genuinely in the interests of the wider society, then that should be incorporated into the decision. And we know very well that just getting mainstream politicians to talk about the issues that we've forced onto the agenda, because make no mistake, Occupy on both sides of the Atlantic has forced politicians to discuss inequality, executive pay, financial regulation, all these things. But getting them to talk about it is one thing, actually getting substantial change is a whole nother ballgame, and that's why we need to keep going.
Justice Lindblom did not comment on any details the defendants brought forward in terms of proportionality, when he ruled that the protest is a greater inconvenience to commuters, worshippers and tourists than it is an inconvenience for the protesters to silence their dissent.
I just don't know how you can negate a legal argument out of a summary. I just don't understand if that's good practice. The idea that what we're presenting isn't factual and is all politically based is actually an absolute insult to the people whose lives have been destroyed because of the processes directly benefiting this country and other countries that are similar. In order to retain the integrity of their value system of monetary kind of worship, they're now trying to take away the stabilizers of any moral imperative that we have to each other as human beings. And it's just excuse me.
John Cooper QC is appealing on the basis of proportionality. This court case certainly has brought to light the fact that the City of London is a corporation with public authority, as well as its own police force, and yet there is no public accountability in regards to its assets.
We've got a lot of evidence in terms of the role that the Corporation of London specifically, as one of the world's preeminent tax havens, the effect that they have on the world as a whole, how they operate as an essentially kleptocratic force that enables trillions of dollars to be removed from vulnerable people across the world that their governments really need to provide for their people. I think we made a very strong case, and that case was effectively ignored by the judge because he didn't feel the law allowed him to include that in his judgment.
The City of London Corporation have acted with restraint, considering their clear desire to see the protest end. One, of course, can applaud this courtesy, but one can also speculate as to whether the City of London Corporation has acted so righteously to avoid any particular public interest in its affairs. Amongst other interests, the City of London Corporation are heavyweight lobbyists for the financial sector in matters before Parliament. Occupy London is planning for a long, tenacious future, pursuing its goals. Included in its campaigns is the implementation of a sustainable financial system that respects the Earth's finite resources. The future of Occupy LSX's stay in between St Paul's Cathedral and the London Stock Exchange is dubious. At this point, an eviction is expected, but when it may come is unknown, and how the occupiers may react to it is also unknown.
We're so sorry. We really do apologise. We didn't know it was so important to you to keep watching the TV.